So hello everyone, myself Advocate Gautam Harshwal, working with LEXIS and Company Law Firm as a junior associate. So today in this video I am going to discuss with you, what is this, sale of ancestral property. Before that, we are going to discuss, there are in India, how many types of properties are there in India. So let's start our discussion without wasting a minute. So the first thing we need to understand is that there are two types of property in India. The first is self-acquired property, and the second is ancestral property. So what is self-acquired property? Self-acquired property basically is a type of property that a person earns in his lifetime, purchase property from his own money, right? A person received through a gift deed, will, or transfer deed. The ancestral property after being divided will also be self-acquired, right? So this is what all about self-acquired property. The second is ancestral property. What is ancestral property? So ancestral property is basically undivided property in which four or more generations of a single family have their share, right? All four generations, and in that property, all four generations must be alive at the time of at the same time, and in the fourth generation. In the fourth generation, example, you were born after the death of a person. So if the fourth generation, example, you were born after the death of your great grandfather, then you won't have any right over the ancestral property. That's all about ancestral property. So let's discuss landmark judgment regarding ancestral property so that it will help you better in understanding your make your understanding better. So the judgment landmark judgment, name of the landmark judgment is Babu Ram versus Santokh Singh, who is deceased basically. In this case, in the case of Babu Ram versus Santokh Singh, a very important issue was decided by the Honorable Supreme Court of India on the 7th of March 2019. It's not so old case; it is a recent case. Can a legal so what the question was, can a legal sell his or her share of the ancestral property to a third person without informing or offering the property to the other legal heir of the ancestral property? So basically, let's further in this video we are going to discuss the brief facts of this case. In this case, there were two brothers, Santokh Singh and the another is Nathuram. Right, Nathuram inherited, among others, certain agricultural land after the death of their father. Right, according to Santokh Singh, an arrangement was arrived at in the terms of which brothers have to be separate enjoyment of certain specified pieces of land. Since since Nathuram was not interested in continuing with the said arrangement, right? So basically, what that means is Nathuram was not agree upon the arrangement which was being made, right? But Santokh Kumar was in the favor, right? And he gave a legal notice to Santokh Singh and later executed a registered sale dated on 19th of August 1991 in respect of his interest in the lands of favor of Babu Ram. So these are the brief facts of this case, and what the conclusion was, on what conclusion Supreme Court at the end reached, that to sum up the concept of ancestral property in vast and complex, and any person who is shareholder in a ancestral property and aggrieved by the sale of share of the ancestral property of another legal heir can file suit in district civil court for cancellation of sale deed for claiming his or her preferential right to the ancestral property under section 22 of the act when the other legal heir tries to sell the property to a third person without offering or taking permission to sell of the property from the other legal shareholder of the ancestral property. So that's what the Supreme Court said this in this case. I hope you understood what is ancestral property or what is sale of ancestral property. If you have any confusion regarding this, let me know in the comment section. We'll discuss in the next video. Till then, bye.